Hello, I'm Tom Shirley. I'm the chair of Choate's Employment and Employee Benefits Group.
I'm Alison Reif. I'm also a partner in that group.
And I'm Art Meyers, also a partner in the same group.
It's a rare company these days that doesn't have employment agreements with its senior executives. Given their prevalence, it's surprising how frequently common drafting points are mishandled. Today we'd like to talk about a few of the more important things to get right.
One of the more heavily negotiated points in the employment agreement is the cause definition. It's the trigger for severance for the executive, so it's typically quite important. The definition usually has 4 or 5 parts, including items like willful misconduct, felony or misdemeanor convictions, and other such misdeeds. It's helpful for an employer to qualify each of those subparts with a clause that says, as determined in the good faith sole discretion of the company, so that it has the ability to determine when, in fact, those events have taken place.
Contracts for more senior executives sometimes also have what is known as a good reason provision. These kinds of provisions allow the executive to resign and receive severance if there has been a defined material negative change in the employment relationship. The important point to remember here is that an overly broad provision can subject the executive, not the company, but the executive, to punitive excise taxes under Section 409A of the tax code. Here's an important and easy drafting point to remember. Section 409A has what's referred to as a safe harbor definition of good reason. Keep within its parameters, and you'll also keep out of trouble.
Tom referenced Section 409A of the Internal Revenue Code. That section governs the time and form of payment of non-qualified deferred compensation. With certain exceptions, severance can be non-qualified deferred compensation. If it is non-qualified deferred compensation, then an employment agreement and a separation agreement must contain special language that coordinates the timing of the execution of the release with the commencement of the benefit payments. If these requirements are not satisfied, then the executives can be subject to substantial taxes. If an agreement is non-conforming at the present time, under certain conditions, it can still be corrected if those amendments are undertaken in the calendar year prior to the year in which the separation from service occurs.
So Art mentioned a release of claims. Severance is a very important aspect in an employment agreement. It is critical for the company to make sure that any severance entitlement is conditioned on the executive signing a release of claims against the company at the end of the employment relationship. There are a couple of ways to handle a release. One way, and the preferable way for the employer, is to simply include a clause that says severance will be conditioned on the executive signing a release in a form acceptable to the company. From the executive's perspective, he or she would typically prefer that that release be drafted in advance and attached as an exhibit to the employment agreement.
Alison referenced the execution of a release. As consideration for such releases, companies often continue to provide continuation of group health care insurance to terminating executives for a period of time after their termination of employment on the same terms as if they were still employed. Doing so can create several problems, one for an insurance policy and the other for the IRS. With respect to the insurance company, the employer must obtain their consent to do so, otherwise the insurance company might not pay the claims. With respect to the IRS, depending upon whether the plan is insured or self-insured, tax penalties can arise for the executive or for the company. And in fact, if a policy is fully insured, a company can be subject to an excise tax as high as $500,000 per year under the new Affordable Health Care Act. There is still an opportunity to correct these offending provisions in an employment agreement, but one must do so in the calendar year prior to the calendar year of termination of employment.
A final few words on dispute resolution. What to do if your employment relationship with an executive ends badly. Arbitration can confer one important benefit: confidentiality. On the other hand, an award typically is not appealable, and experience is teaching us that it can be just as expensive and as time-consuming as litigation. As a result, many companies are returning to the courts. If this is the path you choose, 2 practice pointers. First, you'll almost always want a provision that waives both parties' right to a jury trial. Second, be sure to include enforceable choice of law and forum selection provisions.
We hope you've enjoyed our brief presentation. Feel free to contact any of us with your questions. Thank you for joining us.